Imagine walking into a courtroom thinking the rules don't apply to you. That's exactly what 22-year-old Miss Wilson did. Already charged with drunk driving and causing an accident, she had racked up more than 15 bond violations. Instead of following simple court orders, like attending alcohol tests or wearing a scram tether, she kept making excuse after excuse: no childcare, no transportation, too busy with work. But in a courtroom, too busy isn't a valid defense. Judge Simpson made it very clear that bond conditions are not optional. Repeatedly missing tests, delaying monitoring devices, and showing up late wasn't just inconvenient, it was arrogance and a blatant disrespect for the law. Even when she had free time, she refused to comply. Her actions didn't just frustrate the court, they shook the foundation of trust that probation and bond rely on, and they put public safety at risk. The tension in the room grew as her excuses piled up. The judge didn't hold back, calling out her behavior as irresponsible and dismissive. This wasn't just about one failed test or a late tether, it was about a pattern of defiance that threatened to spiral into much bigger consequences. In the end, the verdict was clear: Miss Wilson was sentenced to 5 days in county jail. The court sent a strong message: freedom is a privilege, and repeated defiance has serious consequences. Jobs, housing, insurance, and reputation can all take a hit when someone shows such disregard for the law. This case is a stark reminder: excuses don't work in court. Arrogance and noncompliance will be met with real consequences. If you think you can bend the rules, think again. The law doesn't take "I'm too busy" lightly.
The bond violation, or sentencing on the violation. Did you get the new report?
Yes, I did, Your Honor.
Is there anything you want to say before I?
Yes. But I'd like to start off. Miss Wilson is a 22-year-old. She's very apologetic to the court. For the initial violation, she was upfront and honest about the dirty blow, and she admitted when presented to her. There was a delay for the tether, which I believe is what you're referencing on the report. The day of court, she did, that was April 17th, she did go to community corrections, but because she had her child with her, community corrections do not allow kids within the facility. She did not have a babysitter at that time, and she wasn't able to get the tether fitted that day. On the 18th and 19th, likewise, she did not have a babysitter. She also does not have a valid license right now, so she is not able to drive herself to the facility. She relies on others to help her out with rides. So that is why she wasn't able to get the tether fitted until Monday. She was going to try to go on the weekend, but since the community corrections is closed on the weekend, she wasn't able to do that. She is working full-time, works at EHM Senior Solutions in Saline. She's been there for the last 4 years. She works, she also is enrolled inside school full-time, inside the nursing program, and she's a full-time mother. She has no one to really help her with watching the kid during the day. So we'd be asked that she be allowed to continue on bond while this case is pending.
Anything from the people?
We leave it on the court's discretion.
The problem that I have, Wilson, is that on the 17th you admitted to the violations. We set the sentencing out to today. In the interim, because there was a dirty flow, I had told you to report to community corrections to get on a scram tether immediately. That was on the 17th. It was not until Monday of this week that in the late afternoon on Monday that you put yourself onto a scram tether. I'm trying to figure out why.
Yeah. I worked both.
What'd you say?
I worked Thursday and Friday, and yeah, I have my kid up until I go to work. And I also didn't know that my son couldn't go in there because I went over there after court. And
I understand that. But that was on Wednesday.
Right. And then I worked Thursday and Friday, and they weren't open the weekend.
Did you work Monday?
No.
Then why did it take you till 3:50 on Monday to get there?
Drop my kid off to his dad. Or he can come get his kid. That's why.
So she usually starts work at 3 p.m. until 11:30, and that's whenever the father of the child takes the child. Before then, she is usually watching the child.
Well, not watching.
Tell me how I know that you weren't drinking over the week. I mean, young lady,
I don't.
you're here on a drunk driving case. I put you on a sober line, right? The alleged blood alcohol content was 0.085. There was an accident. During the course of this, you're not blowing when you're supposed to, and then I have a dirty blow. I should have sent you to jail that day, and I didn't do it. And I didn't do it giving you an opportunity to maybe show during this week that you could exist with a scram tether, not drink.
I'm confused with the last part you said, because I got the tether.
Oh, I know.
Oh.
5 days late. So I guess the record's clear. Between the time of the 17th to the time you got the tether, you didn't blow into a sober leg either.
Yeah, because the device locks. I didn't know if that was because
Because you were supposed to probably be on a scram.
Right.
And she did inform me of that. She did inform me of that yesterday when she tried to test on the sober link on the 18th. It gave her an error that it had to be reset.
And you did nothing.
Bring my kid in there, I can't.
But you did nothing. And then, let me ask you this. Do you not take this seriously at all?
I do take it serious. I'm busy. I'm a very busy person.
Okay.
And that's not an excuse.
We all are.
But it's kind of inconvenient for me. That doesn't mean that I'm not doing anything. I've been coming to court
This is all inconvenient. Because you decided allegedly to drink, get into a car, and have an accident. That's all inconvenient. But if true, no one in this room is the cause of that inconvenience except you.
I think her youth plays an age inside this. She's only 22. This is her first criminal case.
I'm not even 22 yet. My birthday's Friday.
So she's 21. This is her first criminal case. I do think that going forward, she's going to take this very seriously. Whenever I talk to her.
But Ms. Coons, I appreciate that. But at what point? Because if you look at this report, I have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. Well, let's say 20 violations of basically, well, actually, it's not quite that many. It's about 15 violations of the program itself in terms of when she was supposed to blow. Then on the next one, she drank. Then even after that, that was on April 5th. By the time we get the report, she reports back to court. I have on April 6th, she didn't test during the time frame. On the 7th, she didn't do any test. On the 8th, she didn't do any test. On the 10th, she did not test between 7 and 10 as scheduled. On the 12th, she didn't test. On 2 occasions for her testing that day, between 7 and 10 a.m. and 2 to 5 p.m., she didn't test as scheduled. On the 13th, she didn't test between the 7 and 10 a.m. She did do a makeup test an hour and a half later. On the 13th, she didn't test between 10 and 1 a.m. as scheduled. She tested at basically 2 o'clock in the morning on the 14th. She was negative. On the 14th, she then, on that day, still didn't test between 7 and 10 as she was required to do. And then basically 40 minutes later, after the testing window, she tested. And then later that day on the 2 to 5 test, she didn't test as scheduled. That was on the 14th. That's just this month. And then she appears before me on the 17th. I give her a break by not remanding her and tell her that she has to get a tether. And then I get here, I'm now, and set this out to the 24th, and now I get here and she's too busy and it's inconvenient. Really.
I can understand the court's frustration.
Oh, I'm not frustrated. I'm just,
Yeah.
I don't get frustrated.
Yeah. Well, she does have the tether on, so it would negate any further missed test, Your Honor. If she's able to continue on to bench.
So I'm just supposed to say, don't follow anything I told you to do.
Absolutely.
Just go on your merry way.
No, absolutely not. But when we spoke, she did state that she'd like to continue this case. She'd like to stay out on bond. She's able and willing to comply with all further court orders.
How do I know that?
I've been coming to court all year. I haven't missed a court date.
Yeah, you're right. You haven't missed a court date. You've missed a lot of tests. You missed going to community corrections. You went there when it was convenient for you. Young lady, that's not how this works.
I mean, I didn't have a choice. I can't bring my kid in there.
I get the 17th. You needed to find a way to make an arrangement on the 18th and 19th so that we're also clear on the 19th. On the 18th, community corrections talked to you that day. Mm-hmm. And you told them that you would report to them on the 19th.
Yes, because I thought I could, but I couldn't.
That's a Friday. Mm-hmm. And you didn't report on the 19th. You didn't call to reschedule or offer to them, according to this report, any explanation for your not reporting. You just didn't show up. And then on Monday, even if I accept your rationale that you were working and that in terms of working, you couldn't make it, even if I accept that rationale, which I don't, Monday, you weren't working. And you still didn't go until late, actually, after the agent that's assigned to your case at community corrections had left. And you're lucky that somebody else there stepped in and put you on a scram tether, because otherwise you'd be showing up today with no tether. And mind you, the person that did that did it after the agent that's assigned to your case had terminated you from community corrections supervision because you weren't compliant. Anything else?
Nothing further, Your Honor.
Lady, you're going to have to learn to just pay attention. When court tells you to do something, you're going to have to do it. This isn't all about you. Everybody has busy lives. And I can appreciate it when I see people try. What I see in this report is somebody that's not trying. That somebody is putting other priorities ahead of what your obligation to this court is and what your obligation to this case is. And again, allegedly, you made the decision to drink. You made the decision to get into that car. You made the decision to drive. You made the decision to have that accident. It's the sentence of the court. Defendant remanded to the Washtenaw County Jail to serve 5 days for the violations to date. Mr. Allen, you may take her.
Imagine thinking the court will bend the rules just because your life is too busy. That was exactly the mindset of 22-year-old Miss Wilson. She had been charged with drunk driving and causing an accident, and by the time she arrived for this hearing, she had already accumulated over 15 bond violations. Instead of taking her responsibilities seriously, she offered excuse after excuse: no childcare, no transportation, too much work, too inconvenient. To her, these were reasons to ignore court orders. But the courtroom isn't a place for convenience. Her attorney tried to defend her, highlighting her age, her first criminal offense, and the challenges of her daily life. They argued that she needed flexibility to comply with bond conditions. But Judge Simpson wasn't convinced. The law doesn't adjust for personal schedules or excuses. Repeatedly missing mandatory alcohol tests, delaying the installation of a scram tether, and failing to comply with deadlines isn't a small mistake. It's a pattern of disregard that the court cannot tolerate. The judge's frustration was clear. Even when Miss Wilson had time off from work, she still delayed compliance. Her repeated failures didn't just inconvenience the court, they demonstrated a lack of seriousness and respect for the judicial system. Bond and probation are opportunities, designed to let defendants prove they can manage freedom responsibly. Ignoring these orders not only risks public safety but also undermines the trust the court places in a defendant. As the hearing unfolded, Miss Wilson's attitude became the focus. Her repeated excuses, claiming she was too busy, didn't have childcare, or couldn't arrange transportation, came across as dismissive and arrogant. The judge emphasized that bond conditions are not optional or negotiable. They are rules established to protect both the defendant and the public. Defiance in the face of these rules signals a deeper problem, a refusal to take responsibility for one's actions. The courtroom tension grew as her attorney continued to argue for leniency. But Judge Simpson's message was firm. Excuses do not erase repeated violations. Ignoring simple court orders demonstrates disrespect for the law and jeopardizes the trust necessary for probation and bond. The judge explained that probation isn't a gift, it's a second chance, one that comes with clear expectations. Those who fail to respect these conditions show that they are not ready for that responsibility. Miss Wilson's repeated failures to comply had consequences beyond the single hearing. The judge noted that such behavior can have long-term impacts, affecting employment, housing opportunities, insurance rates, and personal credibility. The courtroom isn't just about immediate punishment, it's about preparing individuals to function responsibly in society. By ignoring bond conditions, she was undermining her own future. Finally, after considering the repeated violations, the judge delivered his verdict. Miss Wilson was sentenced to 5 days in county jail. The decision was a clear warning. Freedom is a privilege, and it comes with rules that must be followed. Arrogance, excuses, and repeated defiance will not be tolerated. The court's authority and public safety are paramount, and anyone who disregards these principles will face serious consequences. This case isn't just about one young woman. It serves as a cautionary tale for anyone thinking they can ignore the law. The court provides opportunities, but compliance is mandatory. Ignoring court orders, missing required tests, or delaying mandatory monitoring devices has real consequences. Excuses are not a substitute for responsibility. For viewer watching this unfold, it's a stark reminder, accountability is non-negotiable. The law doesn't care if you're busy or inconvenienced. Freedom comes with responsibility, and repeated failure to uphold that responsibility will catch up with you. Miss Wilson's story shows that ignoring rules doesn't just risk jail, it can impact your entire life, from personal reputation to future opportunities. Ultimately, this courtroom drama is a lesson in consequences. Excuses may delay accountability for a moment, but they cannot prevent it. The judicial system is designed to ensure fairness, but it also demands respect. Miss Wilson's arrogance and non-compliance made that clear. Her 5-day jail sentence is a warning to anyone who believes they can manipulate the system or treat it lightly. The courtroom is not a place for convenience, It's a place where actions have consequences, and the law will always hold individuals accountable. This story should serve as a wake-up call. Freedom and opportunities are never guaranteed, they must be earned through responsibility, honesty, and respect for the rules. Ignoring this reality can lead to immediate punishment, long-term setbacks, and a life complicated by poor choices. The court's decision in this case illustrates a fundamental truth. No one is above the law, and accountability is inescapable. For anyone watching, remember, the law is patient, but it is also firm. Excuses will only take you so far. Ms. Wilson's experience shows the importance of taking responsibility early, following rules diligently, and understanding that every action, or inaction, carries weight. Ignoring obligations may feel convenient, but the consequences are always real and often severe. This case, while dramatic, is a reminder for everyone. Freedom is earned, respect is mandatory, and accountability is inevitable. Those who fail to understand this risk losing far more than just a few days of liberty. They risk their future, their reputation, and the trust of society. Ms. Wilson's story is a lesson in how small acts of defiance can escalate into serious consequences. In the end, the courtroom speaks a simple truth: responsibility cannot be ignored. Excuses cannot replace compliance. Freedom is a privilege, and those who treat it lightly will pay the price. Ms. Wilson learned this the hard way, and her experience serves as a warning to anyone thinking they can ignore the law. Every choice matters, every action has consequences, and the court will always hold you accountable.